to get started. I want to thank you all for coming out. This is the women who wins the league. The women that we'll be speaking to today are amazing trial attorneys. I'm sure you know all their accolades. The first woman that will be speaking is Windi. Before I start with that, go Windi! Into the reason for this. The reason we chose this type of CLE is because there are topics all across the board, and gender is one of those topics that you have to address. It's just like being a criminal defense attorney and not knowing how to discuss and or present race as an issue. It's something that comes up. It's something that you have to address in some of your cases, and if not done properly, it can go really bad really quickly. These women attorneys are not just all right attorneys, they are phenomenal. They are good at what they do, and they've done it successfully. The first person we'll listen to this on today is Windi Akins Pastorini. When we send out emails within the office, who are some amazing trial attorneys people will be interested in seeing? It is one of the names we got for that. I wasn't as well versed as one of my coworkers, Lori Hooch, who sung her praises, so I did my research. It's perfect to speak on this topic. Windi presents her cases in a dynamic way. Most notably, she had a client. The client was young, charged with murder, his father. When the media coverage started out on that case, let's just be honest, the child was everything but a child of God. He was a monster, she was a monster. It was really, really bad. But during her whole representation, she took the motherly approach. And that's the way she talked about her client to the media. That's the way she handled her client in every setting. And before, the not guilty came, public opinion had turned. Not only was the child given a second chance to go out and do life over, that child doesn't have the stigma that, someone like Casie had, where everyone in society is looking at you as a monster. She was able, through her representation, to give that child a fresh start. Other women issues. She represented a client in charge of prostitution. Factually speaking, it looked bad for the client. But she was able to draw on something as a woman that no other person should have to endure. After it was all said and done, the officers came in and they took pictures of her client on their phones. Windi went in and she argued the heck out of that case and put the prosecutor in a position, look, if you try this trash, I'm going to get the jury to welcome, and after she secured her client's dismissal, she didn't stop there. Those clients won't, or those officers won't have the chance to victimize somebody else because they're not there anymore. She put in that work. So this is somebody that not only does it, but she does it outside the box and always looks for the best way to, impact her client's life, and I think that she has tons to tell. Thank you.
Don't know that I deserve that, but thank you so much. I feel so much better about myself. Anyway, I'd like to just talk a little bit about things that I think help us win. The first thing that I want to talk about is about every week, or at least a couple of times a month, we tell our clients, you have the right to remain silent. Use it. And that's the big advice we give to our clients, but it's also advice that we should be taking. We should take that advice when we're talking to the prosecution. Don't tell them everything. We have a right to remain silent. One of the strongest things that we've got as criminal defense lawyers is we have the ability to conduct trial by ambush. They don't know what we know. They know what they know, and they know what they think they know. They don't know what we know. I think that you've got to really be careful at the outset of the case. If you think that case is going to have to be tried, now this doesn't apply to everything. If it's going to be pled and your client just wants you to work the best deal you can, then I don't think this really applies to that. But if you think that case is going to be tried, be careful what you feed the prosecutors. There are some in that office that are wonderful, that would do anything for you and are honorable beyond reproach. And there are others that are just the total opposite end of the spectrum. And unless you know them well enough to know how much you can share with them, don't give them everything if you're going to have to try this case. Let them, feed them little tidbits. Give them to tell you things, or you tell them little things. See how they handle it. Keep something back, something that they don't know. I can give you some examples. I can give you, it's really hardcore example, but I had a client who tried to sexually assaulting his living girlfriend. Now this is, you got to think outside the box in some of these cases. And she knew him, so there's no identity issue. He knew her, no identity issue. He's arrested in the bedroom in her apartment by the police who come in the middle of the night. She said that he sexually assaulted her. She was about this tall, very thin, very frail, and she had spandex everything. She had spandex clothes, she had spandex shoes. She was all about looking hot in her spandex and, short skirts. And I'm not saying that's bad, because that is good, because she had a real handsome, tall, great big former basketball playing boyfriend. But she wanted him out of her life and out of her house. And so what did she do? She said he sexually assaulted her. There really wasn't, she wasn't a rape kit, and it showed nothing other than she had, that she had complained that she had been sexually assaulted, so they thought maybe it was because he wore a condom. And the problem with that is that she didn't seem to have any recollection of that aspect, but there was no sign that anything had happened, except for the fact that she swore that it did, and she was so hot, and these little officers could not, they were just blinded by her, I think. As time went on, this was in Mike Anderson's court, and Mike Anderson found a reason to revoke him and put him in jail. His bond, he contacted her to say, I'm sorry you're going through this, I didn't do anything, I'm just sorry, and it didn't work. And Anderson put him right in jail, so he thought he was going to kill her. So he put him in jail for 8 months. During that 8-month period of time, I went to see him a couple of times and said, what is our defense? Do we have a defense? Then you had sex with her, right? He goes, well, no, I didn't have sex with her because she and I both have herpes, and it was one of them, I don't remember which one, was having a bad episode at that time, so they didn't have sex. And I said, well, okay, did she take medicine for it? Yeah, he told me the medicine. So that got me a little bit of negative press for her. And then the next thing I know, I said, is there anything unusual about your penis or something? I'm looking at everything. I'm grabbing at straws. He said, I have an abnormally large penis. And I said, that's what every man I've ever met said. And I'm in the holdover cell up at the jail, and I'm talking to him, and I could judge for myself. I'm not about to let him show it to me for obvious reasons. Who knows, there may be a camera in there running something. I'm working on this defense for a sexual assault. So I didn't think they would buy that. I said, look, you got to do more than that. How big is it? He goes, it's weird. Okay, so anyway, I go out and I call a urologist. Tell him what I wanted to do. I want him to go to jail. Take a look at this man's penis and tell me, is it abnormally large? This urologist said, this is a joke, right? And I said, no, I'm serious. How much would you charge to do that? I'll pay. We'll pay. And he was a retained case. He said, I'm not doing that. So that was out. However, we never told the prosecution about that penis issue. My theory was, if it's that big, it would have left no mark, with or without a condom, unless she had loaned him some spandex condoms or something. But the girl that referred him to me, I'd asked her the question, and she verified that it was true. So I kind of had something to go on. But I never told the prosecution that. And I kept thinking at some point this would go away, and it never did. We could show it in court. And during the trial, she has no idea where I'm going to go with this question, neither does Judge Anderson. And I said, she's on the witness stand, and every time I get within 5 feet of her, she just starts shaking, and then I back up, she'd quit shaking, and it was kind of entertaining a little bit. But I was afraid the jury felt sympathetic. By the way, we had 7 men and 5 women on it. Excuse me, that way around. 7 women and 5 men on it, and I knew that they would hate her. I didn't like her. But, and I knew that they wouldn't feel very sympathetic toward her. But I got on the witness stand, and when she wasn't really thinking, I said, isn't it a fact that Brian's penis is abnormally large? And she goes, yes, a little nervous like. And I said, and isn't it so big that when it's erect, you can't even get your hands around it? She goes, yes. I said, in fact, can you get both hands around it if it's erect? And she goes, oh. And he goes, and I said, and isn't it true that it's so so long, because I had no idea. What Loverboy told me, and he said, she goes, yes, and I said, and isn't it fact that it is, and Judge Anderson said, Ms. Pastorini, I believe the jury has the picture, move on. So I had to move on from that. But they got the picture, and our argument was, it would have left a big mark if that had happened. I mean, she was, and the jury bought it, we got her not guilty of the thing. But I tell you, it's one of those things, don't tell them everything. Don't let them know that you have something that you can surprise them with. There was another surprise in that case which I really liked. There was a lady who's now a defense lawyer who was the prosecutor in that case, and the Friday before trial started, the Thursday or Friday before we picked a jury, she gave me 800 hours of audio telephone calls from the jail between my client and others. 800 hours over a 9-month period. And I asked for a continuance, denied. So I thought, you know, don't get mad, get even. We tried the case, and she brought in 5 women from other states that he had either pushed down the stairs or stole their car or, you know, been abusive to them, and they were going to be punishment witnesses because she was so sure she would win this case. So the night that we were getting close to the end of the last day of trial, and I said, Judge, no, we approached, I said, I'm considering putting my client on. It'll take a long time, so can we adjourn? And he said, I think that, you know, they were all salivating, thinking, oh, she's dumb enough to do that. Judge said, oh yes, we'll do that. We can resume tomorrow morning. And I'm sure that this lady went home that night and wrote all night long the questions she was going to ask this guy that is, you know, a pretty bad guy, but not a rapist. And I think he's outgrown it, by the way. He's not. In fact, I think he's a pretty nice guy. But anyway, long story longer. Oh no pun intended. The next morning I showed up, and remember they had those 5 girls that were waiting in the hallway with, you know, dolled up with makeup and all this. Those 5 women didn't show up because they thought it was going to be me putting Brian on, and then the district attorney's office cross-examining him. Well, the judge said, okay, call your next witness. I said, defense rest. And I mean, in the courtroom, I was like, oh my God. Because, you know, they didn't think they had to be there till 1 o'clock. They were out partying like rock stars and sleeping late at the hotel, which is what they were. But there was no rebuttal for them to put on. And the judge, so she rested behind me, and the next thing you know, he gave them an hour and a half to get people up to sit in the audience. And by the time they got there, they didn't look half as good as they had the day or two before. But the good thing is, don't tell them everything. Don't tell them if you're going to put your client on, if you're not going to put your client on. That's none of their business. You need to keep things secret. Remain silent. You have that right. And you have to do that for your clients if you're going to try their case. You think a lot of these prosecutors are your friend? I used to be a prosecutor with Miss Mingledorf here. We were good prosecutors. We were nice people. And if we told you something, you could back it. But there are people out there that just want to know what you know, and they are busy. I've never told them anything that they're not busy writing it down, and flipping over the page and writing some more. Don't tell them, okay? That's the first thing I'm going to tell you. The second thing I would like to talk about is you've got to be very suspicious these days of the Houston Police Department. I hope there's nobody here whose toes I'm stepping on. But in the last 2 years, I've had 3 cases where audio statements have not been produced. And I found out about them in strange ways. Number one, at the sentencing hearing on the case we pled, and this judge was going to sentence our client, I found out that the complainant had given 3 statements, not 2 statements. And I approached, I said, Judge, you know, we've only got 2. I want to know what this 3rd statement is. And the DA says, well, we don't have anything, we just have 2. The judge was kind enough to let us adjourn, call the police officer over, he brought the disc, he had 3 statements. The 3rd statement said, I know what happened to me that night because my friends told me what happened. He didn't see anything, and all the stuff he told on the witness stand was not true. He didn't know what happened. He got shot, and not bad, he's not hurt bad, but he got shot, a couple of grazed wounds, and one of them went through his leg, but it didn't break a bone. You know, but it wasn't my client who shot him. He blamed my client because that's what his friends told him. And so I made a motion to set aside the plea, and it was untimely because we were already at sentencing, and the judge, though, I proved up that I could not have rendered effective assistance of counsel with not having been given what I had asked for, and they had not given it to me. First of all, they didn't say they hadn't given it to me. I get it, and it's on this disc, and I have my disc, and I can show that this conversation's not on there. Second thing was in a murder case, and I think this is prosecutorial misconduct, but you guys, we found out after we had rested our case right behind, well, it wasn't right behind them, the state, but we found out that there was our clients had called the police over and given them a statement in the jail, and it had never been produced. And this lawyer had the audacity to say, we just found out about it, but there were two co-defendants. So as soon as the judge gave us a continuance, it was Frank Price, the most wonderful judge, I just love him. He gave us some breaks over the night, and we talked to the two lawyers of the co-defendants that were not charged with the murder, they were charged with another offense. And they go, we know about that statement she gave. She gave it to us. She gave it to us months ago. And I said, can you be in court at 8:30 tomorrow morning? And they said yes, and they came over. Turns out, Frank called over, Judge Price called over to the district attorney's office and had her chief come over and said, you understand what's going on here, and y'all need to make a decent offer and get this case to move. And it did. The third thing, and I'll give you a little bit about this, is in federal court this past week. We had, when they give you Gene's material, which is material before a witness testifies, so that you can be prepared for what they're going to say and you can know what they have said before. Over the weekend, while reading this Gene's material, I find that there is a 2-hour recorded conversation of my client. And Judge Hittner, of course, would not give us a continuance on that. He said you can listen to it when on break, we're picking the jury. So that was lovely. And the bad news is there's a guy over there, and I'm going to name him, and it's not like me to out people in their full name, but Rick Haynes is the guy, and I want you to be real careful in any time that you have any dealings with him. He said on the record, he said, I gave Mr. Ardorn, which is Jimmy Ardorn, and Ms. Pastorini the same disc, and that statement is on there. And I said, Judge, I'll play it for you right now. It's not on there. And I'm up there elbowing Son Tran, who's trying to. I said, it's not on there, is it? and he's like, he's got his computer. He's looking. He says, no, it's not on there. Anyway, and then when we said, hey, Judge, I've got these. I'd like to offer them to evidence. And Rick said, no, I'm not talking about that disc. I'm talking about another disc that I gave Ms. Pastorini only. Well, that never happened, by the way. But anyway, we got through that mess. And on the third day of trial, we find out that there, and this is an interesting thing, officer on the witness stand says, I read a 300-page offense report last night, and that's in preparation for my testimony. We've never had a report that big. And Ginny Basil was the prosecutor, and she said, well, I'll give it to you over break, overnight, you can review it, and you can continue with this witness. We found out overnight that there were all these statements alluded to. If you go down to HPD and they take a statement, there were 8 different witnesses, including one of my client, and there were 14 different statements. And she, at his son's credit, he itemized them for her, gave her the sticky and said, surely these were recorded. And she said, I don't know, I'll send my agent over to look. Comes back at noon, and she walks in the courtroom, and she's carrying a sheet of paper. Now, mind you, Rick's the lead attorney. But thank God for Jeannie Basil. But she walks in, she's carrying a piece of paper, and I'm thinking, oh God, what did I do now? I didn't know what had happened, and it was very nerve-wracking for about 10 seconds. And she said, Judge, I have to approach. There are some missing statements, and he called the police over, and started to make them justify it. And then I think he realized that he was going to give us a firm jeopardy claim, but he didn't make them justify anything. He just said, you've caused a lot of trouble here, and he, for his third time in 29 years, he declared a mistrial because we had so much evidence, third day into trial. But Ginny Basil, you deal with her, she's honorable. You deal with Rick Haynes, I want you to do this. You send over you get anything, you itemize what it is he gave you, and you send it to him in an email with that little receipt thing that comes back to you, and that's not enough. Then you send him, if he doesn't confirm, say, I've sent you this and I've sent you that, and I haven't heard back from you, would you please confirm? And he may or he may not, and if he doesn't, then you're going to have to go further with it. He will not go to any extraordinary lengths to find it. And in fact, if it had not been Gene Basil, I'm afraid that he would have said, We gave it to Ms. Pastorini at the beginning of this thing. I don't know where it is. You know, she has all our information. And that's wrong. You've got to read those reports. Read them in detail is the best advice I can give. The second best advice I'd like to give you is if you think the case is going to be tried or you feel like there's a chance it'll be tried, get the audio statements, get statements from all the witnesses, audio recorded. Whether it's, you know, maybe you won't get a video statement, call up these witnesses, get your investigator. If you can't afford an investigator and it's a retained case, and I'm sure they've paid you all the money they have, then you can get the AKE motion. It's AKE, some people call it AKE, some people call it AKE, but I think the correct pronunciation is AKE. Get an AKE motion which says, you know, even if they have a retained lawyer, they're entitled to court-appointed assistance.